so the first docket on the agenda we've got is the attorney's fees and notes docket. And as you remember, Judge Michael Robinson was the one who initially requested that you all look at this. You all worked on a draft, and we circulated it over the summer. And we widely circulated that over the summer. We got quite a bit of feedback. We got feedback from the Creditors Bar Association, the Center for Responsible Lending, the Administrative Office of the Courts, and the Department of Justice Consumer Protection Division. And we've got some guests here for that. Stephen Lader, who is from the business law section of the Bar Association. I see him on WebEx. Betty Souza, who's a member of the North Carolina Creditors Bar Association, is here. Lynn Weaver from the Consumer Protection Division of the Department of Justice is here. And Rochelle Sparko from the Center for Responsible Lending as well. And I was just talking with Ms. Weaver and Ms. Sparko, and they indicated that in addition to some of the comments that we received, they would like to share the draft with some other attorneys they know of, consumer bankruptcy attorneys. So we were thinking we could still go through the draft and everything, but I just wanted to highlight that they would like to maybe look at it some more. And there's still plenty of time between now and whenever I would expect the bill filing deadline for next year to be sometime in May. So you've got plenty of time to look at this. Let's see. Oh, and then just to respond to Professor Ludington, if you seek a reimbursement for a meeting, yes, you would need to send an expense form for each meeting you attend. And thank you for that. So here I can go ahead and start sharing the draft. And thank y'all so much. We have a full attendance today, I believe. So thank y'all everyone for starting out the year with a bang. Okay, so I'll just go through the draft. Highlighting represents recent changes. And then there's also some staff notes where I synthesized some of the comments we received. And please, to all the guests here for this, please feel free to chime in, add to anything I say, correct anything I say, add something new. Please don't be shy. Okay. So I'm just going to skip down to page 4. Okay, so on the first line, this change, you all agreed to this change at the last meeting. This was a stylistic change. And then line 3, I just made this reference a little bit more specific because of usually when we're referencing a definition section, we usually just reference the GS section. But because this definition is nested inside another definition, I thought it would be helpful to be a little bit more specific. So that's just a technical change that I made. Same thing on line 7. That's a change that you all wanted. And then here's the first big item, the definition of outstanding balance. So in the current law has a definition of outstanding balance, and you all have worked on a bracketed version, bracketed update to that definition. And there was a question, you all had a question about, is this definition valuable or not? Is this necessary? This definition is only used once in the section, which is it's used in the second sentence of subsection D. So when you circulated this draft, one of the specific questions you raised was, is this definition beneficial? Or should that one instance in subsection D, should we just say total amount owed under the debt instrument excluding attorney's fees, and that way you don't need to have the definition of outstanding balance? And so we got 4 responses to that question. The Department of Justice said that they believe that the definition is beneficial and would be inclined to recommend using the term in subsection D. The Center for Responsible Lending also prefers keeping the definition, and mentioned that the way I interpreted their comment was that there is a similar but separate requirement for debt buyers in the debt buyers article, and that having this definition makes it clear that the requirements of this statute are distinct from the requirements of that statute. And then on the other hand, though, there were 2 groups that went the other way. The Administrative Office of the Courts prefers to just use the term total amount owed under the debt instrument at that time, excluding attorney's fees, in subsection D, so not using the definition, but just using the second alternative in subsection D that sidesteps using the definition. And the Creditors Bar Association similarly commented that the definition treats conditional sale contracts and leases as though they are the same. They are not, and as with other debt instruments, their balances can also be described as the total amount due under the debt instrument. So I interpreted that to mean that they also would prefer to not use the definition, although they mentioned that they mentioned that something they felt like was wrong with the definition, and that it would be easier to just say the total amount due under the debt instrument. So that's the first major issue that I wanted to highlight to you all, and just get your thoughts on that. And let me know if you want me to scroll down to subsection D if you want to see it used in context.
David, why don't you go ahead and do that while we're on the topic?
Yes. Okay, so this is the sentence I was talking about. The first bracketed, there are 2 bracketed alternatives. The first one uses the phrase outstanding balance. The second one does not. This has to do with the notice that the creditor gives to the debtor that they intend to collect attorney's fees, and that in this notice they have to include the amount either the amount of the outstanding balance owed at that time or the total amount owed under the debt instrument at that time, excluding attorney's fees. And that, if you'll remember, if the debtor pays this amount, that within 14 days, then the obligation to pay attorney's fees becomes void.
This is Betty Sousa. Can you hear me?
Yes, thank you.
I'm happy to chime in. First, thanks for allowing me the opportunity to be here. And even though I'm here sort of as a representative of the North Carolina Creditors' Rights Bar, I am not necessarily saying things that have been voted on or decided unanimously, but rather trying to be helpful to the issues at hand. As to the outstanding balance language, I think part of Judge Robinson's concerns really related to the when of how do you determine the outstanding balance. Is the outstanding balance due at this particular time or that particular time? And I think, what he says makes sense in terms of just looking at the language. But in the practical world, which I have much more knowledge of than I do the statutory word worshiping or whatever, it's not usually an issue at all. The notice is given, and in my world, and I've practiced 42 years and collected tons of debts, but also sued on tons of debts that have been uncollectible. I would say that I cannot remember a single time when a letter went out providing the notice to pay the outstanding balance without incurring the obligation to pay attorney's fees, or even putting it into the lawsuit. And I have done both, and I have done both in the same case, and I have done it only in a lawsuit if I could not determine that a previous letter had afforded that opportunity. You have situations where an initial creditor's attorney might be out of state and have made some form of demands, and then that matter comes here, and I just consider it as a right that a debtor would have, and I welcome and have welcomed any debtor the opportunity to pay the obligation. And as to when exactly it gets calculated, to me, doesn't really matter, because you usually at that point are compromising. And I guess I feel like I've never seen this play out with a big problem or issue. The main way it plays out I really don't know anybody who paid up. And there was, trying to figure out how to calculate the outstanding balance. I do think that the term total amount due just makes more sense to me, because what you will have is at that point a lawyer is involved, and the lawyer has the ability to get the calculations, and there might be some disputes over this and that. But from a practical point of view, it just seems to me that total amount due would be a fine term to use, and outstanding balance, I don't know. Perhaps it's subject to interpretation, but I think Judge Robinson's big concern with outstanding balance was kind of the when as much as anything. He's dealing with big cases in the business court. And I offer this thought as well, that a lot of lawyers forget that the district court, the state district court, has concurrent jurisdiction with the superior court. So a lot of collection actions are brought in district court because it moves a lot quicker, and with concurrent jurisdiction, regardless of what some people think the $25,000 cutoff is. District court judges sign $1 million judgments in collection cases, and it's not an issue or problem. The interpretation, if you had to go in and either figure out whether a debtor has made this offer or not in front of a court, and then later with the other issue of determining, I'm trying to think where I'm going with that, but you don't want to clog up having court decisions and having to deal with matters such as this, determining the amount of the lawyer's fees, by having to go into court in courts that do important things with their other cases, such as the domestic law. So apologies for the length of that message, but circling back, I like total amount due just because outstanding balance seems to raise perhaps some dispute opportunity when it really won't matter, I don't think.
David, good.
Oh, yes.
Thanks, Ms. Souza. That's helpful to hear what happens in the real world. And I also, before we left for the summer break, I was inclined to take the simpler path as well with total amount due, and I think I still am, particularly because this 4B has been complicated all along the way. First, we all understand now what a conditional sale contract is, but the time price balance, and I know that that's a carryover from the existing statute, but that's not a defined term. And so I assume that means, in theory, if you had a lease for equipment that you had 5 more years on it and it was, $1 million a year, you would discount that $5 million that's owed by some discount rate. Although I also suspect that there's probably an acceleration clause in most agreements so that the creditor could say the full $5 million is owed. But that time price balance language just, to me, introduces some complexity and uncertainty. Like, do you use the legal discount rate, or how, if there's not an acceleration clause, how do you determine the time price balance? So a combination of simplicity and avoidance of an undefined term, which I think introduces a degree of complexity. I think I also favor the elimination of the defined term and just using the more simple total amount due.
Well, Betty, do you find that the total amount due will vary between the time that you issue the notice letter and the time that you come into court with your, default motion or your motion for summary judgment?
Honestly, in the real world, it would never become an issue, because if there is a debtor out there who has responded or has failed to respond time and time again, because things don't get placed with attorneys until, the client and sometimes a collection agency have been involved and have made demand after demand after demand after demand. And then the lawyer comes in and sends a demand letter, and it probably is tossed, in the trash can. So the idea that how it would play out is in my world, nobody's going to ever really deal with things like the reduction, for a lease that's 3 years in with an acceleration clause, et cetera. They're going to call and make an offer with dollars, and the creditor will make that calculation and make a determination as to what would be an acceptable amount. I think from a creditor's point of view, and particularly, I'm talking about commercial business to business matters, but from a creditor's point of view, call us and make an offer, and you look at the ability to pay. Creditors don't like to have to repossess equipment. They do it as a last resort. So I think of this, again, notice as just being another opportunity for a debtor, if the debtor has money. If the debtor could pay the total balance due, then the matter would never be at this point. It would never, suit wouldn't be filed. There would never be a real challenge here, I don't think.
So your recommendation would be just to leave it in the simplest form?
Yes. And I think total amount due is better and easier.
Well, thank you
I had thought we were
for being here today, Betty. Mark?
Yeah, I was going to say, I was thinking that we would use a reference to outstanding balance only if we were adding a defined term, outstanding balance, which takes us back to what's on the screen here. So we're not going to do that. There's no reason to refer to outstanding balance, and we should refer to total amount due.
Okay, so what I'm hearing is let's take out this definition of outstanding balance, and in this second sentence of subsection D, I'll scroll back down to that. You'll use the second bracketed phrase, since that's the only place that the term outstanding balance is used in this draft. Okay, thank you. I'll keep going. So the next change was on in subsection C, an amount owed. That's highlighted. That's something you all asked for. Same thing at the top of page 7. Owed under. Now this brings us to the next big question. The Creditors Bar Association commented about this last piece of subsection C, and you'll remember the current law says that if the debt instrument does not specify an amount or percentage to calculate the attorney's fees, that 15% of the forget exactly what it says here. 15% of the outstanding balance is what the current law says, is presumed to be reasonable, essentially. This draft changes the law. Then this is something that you all discussed. This was a big issue you all discussed. What this draft does instead is it says that if the debt instrument does not specify an amount or a percentage, a court shall award reasonable attorney's fees not to exceed 15%. And then it uses total amount owed under the debt instrument. So this is a big issue about whether 15% should be presumed reasonable or no, it should be just used as a cap and not as the default. The Creditors Bar Association, they referred to that Colorado Bankers v. Academy Financial opinion, the Fourth Circuit opinion. You all had looked at that. That's the one where the Fourth Circuit had to determine what they felt the Supreme Court, North Carolina Supreme Court, would do, and they said that reading the statute that the 15% was the presumption, let's see, I've got it right here. They said that the plain language of the statute imposing a 15% fee award without requiring evidence of the attorney's actual billings or usual rates, that the district court did not err in not requiring that evidence. And so this is, so I wanted to raise, this comment from the Creditors Bar Association. They were saying that they're in favor of keeping that presumption, and that majority of these cases are handled on either a flat fee or contingency fee basis, eliminating the need for attorneys to capture their time for work performed on the case. So I wanted to pass that comment along and see if Ms. Souza, if you wanted to add anything, and also just to see, commissioners, what your thoughts are on all of that.
I'll be glad to chime in again. This is where I get back to the vast majority of collection actions being filed in the district court divisions. And if judges were required to, or clerks were required to receive evidence as to each particular case to determine whether this amount, which we know would be capped at 15%, and which we probably know is going to be uncollectible at that point, is reasonable or not, is just going to make a lot of judges mad, in my opinion, but it's also going to ultimately be a waste of time, effort, energy, and particularly court time, and frankly, debtor time as well, to nitpick over whether a very simple complaint, whether if you were dealing with an hourly basis client, you may have some agreement that there would be a flat fee rate for filing a complaint. But there are all sorts of contingencies. You can have, back when I was starting to practice through the Commercial Law League, they called it 2018-13. You got 20% of the first X collected 18% of the next Y and 13% of Z going forward. You got a suit fee, part of which you got up front, part of which you would get if you collected, and all sorts of ways to calculate up. But I believe that as opposed to collection agencies trying to continue to collect debts, that getting law firms involved provides some stability. It provides the protections that the law affords a debtor, the notice protections, the opportunity to be heard, the opportunity to file an answer and challenge a claim, the ability to go into the courthouse if a debtor chooses to do so. And I think that the 15% is a modest amount to be determined to be the obligation that is to be paid. And you're just not talking about a lot of money in most of the cases. Judge Robinson's cases obviously would be different. But here it's just, North Carolina legal rate of interest is 8%. And the 15% one time it seems to me to be not only reasonable and fair, but it saves a lot of time to not have to have the potential to challenge something that the only way that any law firm can do a lot of collection work, if they are doing particularly retail collections, credit cards and things like that, is to do it on some form of contingency or partial contingency and get the benefit of doing a lot of it. And so to have to keep up with your time, to have to submit an affidavit, to have a hearing on that for the judge to make a determination seems to be counterproductive with what is in the best interest of debtors.
Mr. Chair. Well,
go ahead, Mr. Haley.
I think what motivated Judge Robinson in part, and my thought in agreement with him, was that there are situations where it's different from what you just described, Ms. Souza, in that the balance owed is significant.
Right.
And then the attorney's fees are out of proportion to the work performed. And so I understand exactly what you're saying when you have a small amount of debt and the administrative burden associated with, proving your fees to be reasonable. So I'm wondering just whether we should have a rebuttable presumption of 15%, but the debtor can come in and challenge that if it is a situation where it said $10 million debt, and rather than the attorney's fees being $1.5 million, it should be significantly lower because the work was not warranting that amount of attorney's fees. So I'm just curious what thoughts are on the possibility of a rebuttable presumption. And I think that Colorado Bankers case was decided correctly under the current law, but the current law allows for this problem where you have the disproportionate amount of attorney's fees on a large outstanding balance.
I agree with what you say. I mean, I think that some form of a rebuttable presumption may well work. What you don't want is, you don't want your judgment to be delayed because you've got to have some subsequent hearing. But I do agree that with Judge Robinson's cases, that 15% may well seem huge, and he would feel that he has no ability to challenge that. I also wonder if you're dealing with the more run-of-the-mill cases as to whether you're almost encouraging attorneys to, for example, send out discovery that isn't answered. Well, we've got plenty of form discovery on most of the types of collection actions, and it's not that somebody just changes the caption and sends it out, but you want attorneys to be efficient and not to take advantage of, not to abuse billing in such a way that the debtor is having to pay. And again, I use the term having to pay, knowing that the vast majority of these cases are not going to end up with the debtor paying 15% or any amount. The creditor probably will be thrilled to get anywhere close to the total amount due. But I think maybe something with a rebuttable presumption, with a burden on the debtor to bring forth something more than, hey, this looks like a lot of money, I don't think they worked that hard.
I've only thought about this for about 3 minutes, so shoot it down as you please. But I was sitting here wondering, where the debt instrument doesn't specify an amount of percentage and just refers to attorney's fees, that suppose we said it was 15%. It would be 15% in that case if the total amount owed under the debt instrument was less than X. Anything more than X, then it would follow this approach. Court shall award reasonable attorney's fees not to exceed 15%.
What are your thoughts on X?
I was hoping you would supply X.
He needs 3 more minutes to come up with that.
I don't know. Is it?
Well, could you?
Is it 100,000? Is it 500,000? Is it $1 million?
I would think that certainly $1 million. I was wondering if you could change it from the business court. You could sort of give them the special business court pass, where the judge, keep in mind, business court has an assigned judge. So you've got a judge very familiar with the case and now feeling that he or she is bound by the 15%. And, maybe that's a possibility.
Yeah, I guess the concern would be that there may be lawsuits involving large, outstanding amounts that don't go to the business court.
Yeah. I mean, I really would love to hear a case where just a collection type of case where the 15% was ridiculously high compared to the work that was done. I mean, those complicated cases have lawyers working by the hour, so they would have the ability to produce documentation easily, I would think, with respect to the amount of work that was put in and built to.
Well, I think that one of the cases that we looked at was that very situation, which is what motivated this. It was a $6 million debt, and the attorney's fees were going to be $1 million, which would seem
more than $1 million.
Yeah. But a couple of thoughts. One is the initial idea of the rebuttable presumption. Now, as I think about it a little bit more, and Ms. Souza's comment about the debtor would have to come in and show there's something more than just this seems out of proportion. I don't know what the debtor would show. I guess they'd have to do discovery to get, and then if the attorneys aren't keeping their time because they're working under a different arrangement. So I don't know how practically the debtor would rebut the presumption other than just to say this amount shocks the conscience and, shouldn't be permitted in light of the complexity of the work involved. And I think Commissioner Bishop's idea is a worthy one to think about, but then just difficult to figure out what that number would be and whether is that going to change over time or is it going to be inflation adjusted or just 15 years from now the General Assembly would come in and say it's no longer 100,000, it's now 200,000 because times have changed. I don't know. There's complexity there too.
I just wanted to ask one question I thought that Betty might be able to answer is on most collection actions that are the small ones, are you in a situation where you're never having to go to court? I mean, you get an entry of default and default judgment before the clerk because it's a sum certain or deemed to be a sum certain because you've got the 15% presumption, or do you usually get an entry of default and then go before a judge to get the default judgment? I guess what I'm asking is if the lawyer is obligated to prove what the attorneys are you having to make an additional step of having to go to court for the judgment itself?
Good question, and I think the answer would be that there's I can't tell you the exact percentages, but are entered by the clerk, okay? And so they're always, from the creditor's side, a sum certain. That sum certain is a calculation of the balance that's due, the interest, agreed to interest rate that's been charged, minus the payments that have been received. And there is, I can't remember, I could probably tell you the statute number and have it wrong, but there's just a verified statement of account shall be deemed correct. And there's a statute in North Carolina that says that. So a typical, let's call it smaller collection action, would have a complaint that would have an affidavit attached to the complaint. And a person familiar with the books and records will say the attached statement of account is true and correct. And it will ask for interest at whatever, the rate might be, and reasonable attorney's fees if those are provided for in it. And that's the complaint. It gets served. It doesn't get answered, and the entry of default and default judgment go to the clerk of court. And clerks of court, I would dare say, that is a lot of what they do, is that it's not just entries of default, it'll be entry of default and default judgment. Sometimes there might be reasons why you can't do it right then with the clerk. Sometimes a debtor might have asked for an extension of time and then not answered, but basically made an appearance. At one point, there was a North Carolina case where a lawyer had received a letter, and I can't remember what the result of that was, but it was either whether the lawyer had some obligation to say that the debtor had responded to the lawyer or not. But there might be reasons that you would go in. But we in terms of our retail section is what I would call it, but that would be more consumer collections. And by that, I mean a consumer debt and not just an individual owner of a business, which would be, a business case. But those cases have to be filed in, it's either the county where the debtor rose or the county where the debtor lives. I think those are the options as far as proper venue is concerned. And so our firm and others would routinely either put somebody on the road to go to counties or would hire another attorney in, Alexander County, North Carolina, to go in and obtain a default judgment. But percentage-wise, it's a lot of the filings, and let's not suggest that the courts are not benefited from all these filing fees. If creditors aren't filing these collection cases, then the revenue of the courts is going to go way down, because there are a lot of cases that are filed that are simple. And let me put in some thoughts for people who would look at this just from the perspective of, that doesn't seem fair that you would be able to get all of these judgments. So many cases do resolve themselves. There are payment arrangements that are entered into, and that can go on for a long period of time. When the pandemic came and people got pandemic money, a lot of old judgments got paid off, and a lot of people were able to enter into agreements and make payments that had previously been in default. So you want people, lawyers, to be able to do this, to be able to bring these claims, because otherwise these creditors have not done a proper service to their owners or shareholders or whatever in terms of trying to collect the matters. But, that's kind of how it plays out.
Well, why don't we move on to the next section? Obviously, we're going to have to spend some more time on this and get some more input from Ms. Souza and also from Judge Robinson. Providing the additional presumption for large judgments or large amounts due might be a way to go, but it also seems like it could be pretty complicated. So why don't we give it some more thought and come back to it.
Okay, thank you, Mr. Chair. So I'll flag that. And then you all have already chosen the second alternative for the bracket language. And then the highlighted language, that is something that you all asked for at the last meeting. So just showing that to you.
Can I make a suggestion on that one?
Oh, yes.
Where it says the amount later to be determined by a court to be owed at that time, could we just carry over the full language and say the total amount owed under the debt instrument at that time, which I realize could be perceived as repetitive, but I think being consistent in this case would avoid any potential question.
David, is there any rule of thumb on that in drafting statutes?
I think that's, from my perspective, I think that's fine. You got to say, if the debtor pays this amount or an amount later to be determined by a court to be owed under the debt instrument at that time, and so on. I think that makes sense.
And the other question I have, which truly is a question and not a rhetorical question, is the use of void and unenforceable. Is void necessarily the proper characterization, or do we want to say that it's, becomes thereafter unenforceable? I guess I always have a little concern about void, which implicitly is, could be ab initio and raise questions about enforceability absent simply having been paid, or even say that it lapses and becomes thereafter unenforceable. I defer on the specifics, but I just have some questions about the use of the word void.
Yeah, let's see. So I think I got that from current law, but that doesn't necessarily mean it should stay in the law. I think unenforceable is the real is the word that probably does more work. But yeah, I would be curious to hear what others think.
Does anyone have any additional discussion on that point that Mr. Lader raised?
I say hear, hear. I agree.
Okay, well, let's make that change in the next draft, David. And
Okay. I'll take out void.
Can I ask a question about this sentence also? Then this is in the weeds pretty deep, but where it says later to be determined by a court, do you need the to be? It read, this felt like a complicated section when I read it, or sentence when I read it. Could it just say amount later determined by a court to be owed at that time?
Yes, I think that's a good change.
Plus you have to be twice in that same clause. So eliminating one of them just makes it read a little smoother, I think.
Right.
David, could you flip back up to page 4 for just a second, the definitions?
Oh, absolutely.
So we agreed to take out this definition based on what we said previously, but what about subpart B? Is that folded in somewhere else, or does that just not matter? I know we kind of talked about subpart A and the decision not to have a separate defined term, but what happens to a little subpart B here?
So that right now that would go away, and there is no other place that discusses that concept.
Andy Hestef, I'm worried about that. I don't know if it otherwise needs to be put somewhere else. I'm not sure.
I mean, I think the idea was that the total amount owed language from the second option in subsection D encompasses both parts of the definition of outstanding balance that's on page 4 now, and is just simpler and less likely to cause confusion.
Okay, so no time price balance option for these other types of contracts. Okay. I'm fine, just wanted to double check that.
sure, come on up.
Either there or there, your choice.
Hey, all. My name is Rochelle Sparko. I'm with the Center for Responsible Lending. I'm one of the people that David reached out to comment on this provision. I've been sitting in the back kind of letting it go by. But now that we're back on these definitions, I wanted to raise a concern that I brought to David's attention from a consumer perspective in debt collection cases. That goes back to this question about, do you need a subsection A or a subsection B, and what happens if you collapse the two and it replace a defined term with just the outstanding, what's the new phrase? The total amount due under the instrument?
Total amount owed.
Thank you. So in the current version of the statute in subsection A, the outstanding balance is described as being the principal and interest. And so there's a very clear amount of money that is included in that outstanding balance, which you then use to calculate the attorney's fee, which is a maximum of 15%. And maybe right now it sounds like is 15%. My concern with the change that you all are considering is that it is not clear to me anymore what is the total amount due under the instrument. Right, it's principal, it's certainly still interest, but is it also any sort of late fee or other fee that gets added into the amount that the creditor is allowed to charge under the debt instrument? And in some cases, I think there's a distinct possibility that could increase substantially the amount owed under the instrument, and then you're using that larger amount to calculate the 15% attorney's fee. I think it could potentially encourage creditors to add fees It's a way, I hear Betty's point very clearly that a lot of this debt is uncollectible or it settles, but in the event that it doesn't and there is a default judgment, if the debtor owns real property, there's a lien against that, and that lien can be executed on. There are other ways to collect on a default judgment, like levying someone's bank account. So, though you may not get a voluntary payment out of a debtor, you could definitely collect at some point from taking their assets or gaining access to their assets. And so I just wanted to raise that concern to you all and say that there is a substantial change potentially being made here to the base amount that's being used to calculate that 15% attorney's fee. And Lynn Weaver, who's here from the Department of Justice, and I have talked with David. We'd like the opportunity to reach out to some consumer bankruptcy lawyers and also folks that represent debtors in collection actions, specifically about the potential impact of this change. Neither she nor I are practicing as debtors' attorneys, and we think that this particular change could be meaningful, but it also may not be, and we would like to check with some folks who are better positioned than either of us are to ascertain that, and would like to share our findings with the Commission. Thanks for your time.
That'll be fine. Do you think you can do that between now and early October?
Absolutely, yes.
Can I just mention that it's a really interesting point you raised, and I hadn't appreciated, the outstanding balance definition in the old statute, limiting it to principal and interest. But the proposed definition that we had before for outstanding balance, it didn't specify principal and interest. So if this is an issue, just reverting to what we decided to delete today, this proposed definition of outstanding balance doesn't address it, and we'd need to address it in some other way. So
I think I appreciate what was said. I think where we would run into trouble is if we are trying to impose something that would be inconsistent with what we've defined as the debt instrument. And so the late fees are part of it. If you had a credit card or you bought something from Pottery Barn, and those are all part of the total amount due, but they're also part of the outstanding balance due. And I don't think that we should start defining what should or should not be included in that determination. It is other than as provided by the debt instrument, because they could be different. I also throw in angle to all of this that I am probably not competent to discuss, but I have a law partner who's shared a lot of it with me, who's unavailable today, and that is a lot of these creditors are national banks. They are bound by lots of statutes, and they are required, when we get into the debt buyers, that becomes an important issue as well. But even as to calculating the charges and what is agreed to and what can be compromised, the banks have got certain duties, and we can't, as a state, start restricting, defining, or whatever that might be preempted by federal law. So I fear that if we wanted to make our definitions more detailed, then we run that risk.
It seems to me that there are two separate things here. One is what the creditor can collect under the terms of the obligation, and that might include the late fees. And, certainly if it's a part of the contract that the debtors agreed to, then the creditor is entitled to receive those. But the current attorney's fee statute modifies that, and it says that the attorney's fees are based on outstanding balance defined as principal and interest, and doesn't include late fees. So I think that what Ms. Sparko's raised is that, you know, we're potentially changing the current law by allowing for greater attorney's fees, and I don't think that's our intent, or it wouldn't be mine. So I think she's raised a valid issue that doesn't implicate the amount of indebtedness itself, but just what the attorney's fees are that can be collected.
Well, Betty, do you want to check with your partner or colleague and come back, communicate with Mr. Unwin, or come back is it the October 5th or 6th when we meet again?
October 6th, right?
October 6th is always the first Friday of the month, except in September.
Right.
Yes, I am happy to, and would feel more comfortable doing that.
Yeah, that would be fine. We spent a lot of time trying to get the statute in this form and had a lot of debate, pro and con, on the exact items we've discussed today. And so we need to take the additional time to try to get all of these things considered very well.
And thank you all. And I just wanted to share. I've shared a chart with you all that compares the current language with the draft language, and I've got some little analysis at the very end. And this is just something that, like what Ms. Barker was saying, the current law says principal and interest owing at the time suit is instituted. And then, like y'all were saying, the bracketed definition of outstanding balance is different. It says total amount owed under the debt instrument, excluding attorney's fees. Also, and this is something that she mentioned to me earlier, which is, and you'll see I've got it, I mentioned it in my notes, that another difference is that the current law has a temporal element to the definition, and it's the principal and interest owing at the time suit is instituted, whereas the draft does not include a temporal element in the definition. Rather, the draft discusses any sort of time issue in the substance of in the substantive language, which for me I did it. I wanted to do it that way because I think that it makes it clear. I don't think the temporal element belongs in the definition, but that is something that has changed, which she pointed out, correctly pointed out, which is that the current law ties that term to at the time suit is instituted, and the draft does not do that. Really, what it says is that when the creditor sends out the notice, it's 15% of the amount owed at that time, which makes sense at the time of giving the notice, and then in C, subsection C, when it says what the creditor can be awarded, what they can recover, it doesn't include a temporal element. It just says 15% of the total amount owed under the debt instrument. And so that presumably that could include interest that's accrued during the lifespan of the lawsuit. So I thought that was a simpler approach, but that is a difference in the law.
How would the current draft deal with it?
So as far as what attorney's fees are ultimately awarded, it just says that the amount awarded when it doesn't specify the amount, or when the debt instrument does not specify an amount or percentage of the attorney's fees, the court shall award reasonable attorney's fees not to exceed 15% of the total amount owed under the debt instrument. And so it doesn't include the concept of owed at the time suit was instituted. It just says the total amount owed under the debt instrument. And I think the thinking there is that whatever if the court is awarding a total amount under the debt instrument, that's a fixed term, and 15% of that can be easily calculated. But it's true that when the court makes that award, that total amount owed under the debt instrument could include, more than principal and interest, and it could include. My thinking is that it could include interest that had accrued during the lifespan of the lawsuit.
So we're back to the when question.
Right, but another reason why I disentangled the temporal element from the definition is just because of Judge Robinson's concerns. Some of his concerns, I think, we're dealing with this tricky temporal issue, and it just seems like by removing that temporal element from the definition, it removes some of his concerns.
Do any of our guests have any comments on that aspect that David just brought up?
I will tell you that I think that the various clerks' offices may have some instructions with respect to some of these matters, determination of calculation. When somebody comes in to, for instance, pay off a judgment, so there is something out there that might, in effect, address this. So if I remember correctly, a judgment may well read, plaintiff is entitled to judgment in the amount of X dollars with interest at from blip date. And then you have some judges that would then say that as of the date of the judgment, it's at the legal rate thereafter. You always have issues as to when the interest rate started. And reasonable attorney's fees in the amount of 15% of the judgment, or 15% of, and they might put it in. So it may well vary. There may not be a consistent way in which it is handled. I also have dealt in the past couple of years with a matter where I got a really big judgment, uncollectible, I might note, except for about $50,000, but the judgment was close to $2 million, and it was in U.S. District Court for the Western District of North Carolina, and then I was able to bring it into Mecklenburg County and trying to figure out how the clerk calculated the interest on the writ of execution in Mecklenburg County was just very interesting, how the court awarded me the reasonable attorney's fees. I sent my notice out and I put my notice, I guess, in the complaint, the outstanding balance notice, and I always give 10 days, even though it said at that time 5 days, and I see that you're going to expand it to 14, which is better. But I just felt like it was horrible to give 5 days, particularly during the pandemic with the mails being what they were, mail service. And the court just did a little asterisk or footnote and said that they noted that the statute only required 5 days and that I'd given 10 and didn't really address it beyond that. But I think you will find that courts and clerks handle the calculation differently. And keep in mind, the only 2 times that I'm aware of that even matters is, number one, when the clerks are getting ready to issue the writ of execution. They are the ones that calculate what is owed and what the sheriff is going out to collect, and there is a writ of execution form in North Carolina, and it's, I don't know, U.S. Marshal Form 285, I think, in federal court. I haven't done one of those in many years, but that goes and calculates up the interest, and then the other time is if somebody were to go to a courthouse to pay off a judgment and say, I want to pay off this judgment, how much is it? How much is owed? Then the clerk at that point would calculate what is owed under the judgment. And in theory, if you've got something like a foreclosure and somebody wants to buy, they're getting the money put in and they've got to disperse it, there would be times like that.
David, there might be something in the clerk's manual about that. I would think that you have one down the hall in the library. And as Ms. Sousa pointed out, it may be handled differently in different counties, but that might be the place to start to look at that temporal issue.
Okay. Thank you. Yeah, I will do that. And it sounds like just going back to the draft, instead of removing that definition, I'll just keep it bracketed for now, since it sounds like you all will want to revisit it at the next meeting, if that sounds good. And then I think we can jump to subsection E. And there were some comments on this one as well. The Creditors Bar Association had a comment just in general about subdivision E1, and they pointed to the Towns v. PRA case that said that a debt buyer is not required to identify with particularity each individual purchase, cash advance, interest charge, or late fee, and so they interpreted this language as going beyond that, and I included that Towns v. Portfolio case, and that case dealt with some statutes in the debt buyer's article, and it's true that there's some language in the debt buyer's article that is identical to the current language in subsection E. And it was the North Carolina Court of Appeals was looking at some related statutes to that language, and I see what they're saying, the court was saying that debt buyers don't have to fully itemize every discrete interest charge, fee, or purchase made with a credit card, and really my intention with E was just to clean up the language. It wasn't to change the law. And so I appreciated that comment. And then before I jump to the rest of it, you'll see I included another alternative, which is just to reference 5870-150. And that language is identical to the language in current subsection E. So it might be simpler just to cross-reference to that statute instead of repeating 1 and 2. And so I was curious to know what y'all thought of that. As a related note, I'll just say as a related note, in the last sentence in E2, that was something that you all had asked about during circulation, to say, this requirement that each assignment contain the original account number of the indebtedness. How necessary is that? And we received conflicting feedback on that, and I can go over that, but I'm thinking that if we just reference 5870-150, that will sidestep that issue, and the conflicting feedback on that last sentence of E2 was that, let's see, so the Center for Responsible Lending said that they thought that the last sentence of Subsection E is necessary because it helps the consumer identify the account issue in the litigation, particularly if the plaintiff is not the original creditor. The account number is required, and then they mentioned some statutes from that debt buyer's article. So it shouldn't present an additional burden to the plaintiff. The NC Creditors Bar Association, on the other hand, said that requiring the account number will result in confusion, given that an account number may be changed during the life of the contract. And then the Administrative Office of the Courts just said they didn't have an opinion on it. They didn't see a court process or procedure impact affecting it. So they didn't really have an opinion. But I'm thinking that given the opposing feedback about this sentence in E2 and the Creditors Bar Association concern about the credit card piece in E1, perhaps it would be simpler just to reference 5870-150. I've got that set out below in a staff note if you want to refer to that, but it is identical. And actually that one was added by Session Law 2009-573, which also amended this statute in subsection E. So that's why they're identical.
To me, the cross-reference seems like a very elegant solution, and I don't understand why. Well, first of all, thank you for tracking down that question about the original account number. I'd asked that question and appreciate hearing that, and I guess it's answered by the statute that will now be cross-referenced. So to me, that seems like the right approach. I don't know why that would cause confusion in the sense that it's required to be in the complaint under the statute we're cross-referencing, right? So anyways, I fully support the cross-reference instead of the repeating the language here.
Any other thoughts amongst the commission or our guests? Well, it sounds like we could make that change.
Okay, thank you. Yeah, and then I just made that cross in earlier on in that adding B4 just made that cross-reference a little more specific because, like I said earlier, that definition section is the definition of debt buyer is nested within another definition. So I thought that would just be a little clearer. And then there's, I think, one more thing. Right. So the Administrative Office of the Courts pointed out a bill that just got enacted earlier this year that eliminated the requirement for a clerk to have a bond. It repealed GS 78-107, and that a conforming changes is needed in subsection E of this statute, and in two other statutes. They mentioned some other statutes that are not being amended in this draft. And they said that they plan to pursue a bill to make these conforming changes. And I asked them, okay, well, I agreed with them that a conforming change is needed, but I wanted to see what they thought they would do to fix it. And they said they would likely seek to delete subsection E entirely. And they said there's no need for it. The clerk's bonds are not required. Deleting the subsection would not shield the clerk from liability. There's insurance in place. So in an effort to match what they're going to do, and it makes sense to me, I think, that is a change, that a conforming change to a recent bill, recent session law.
I think it's a good idea to keep in touch with them and see what they finally come up with, but that's
Yes.
like the way to proceed.
Yes, I can do that.
Okay, David, do you have sort of an idea of how to formulate the next draft, or?
Yes, I can bring that back and thank y'all to all the guests. I'm definitely curious to get your thoughts going forward.
Can I ask, David, are you going to provide some alternatives based on the conversation today about that if it's not specified, the percentage is not specified in the note, Is there a rebuttable presumption? Is there a threshold where it's 15% if it's below that threshold? Will there be alternatives in the next draft? Is that what you're thinking?
I can definitely do that. I could do one alternative that's the way it is now. I can do another alternative with the rebuttable presumption idea, and then I could do an alternative that has the threshold amount and I guess I'll just come up with a number. I'll think of a number, and maybe if others have ideas for the number, but that if it's above a certain number, that you do need to show your work, show the prove the reasonable attorney's fees, but if it's below the number, you get the 15% presumption.
And one thing you could do with that is that you could require, when you say show your work, you could just require an attorney to provide an affidavit that their work exceeded the 15% threshold or whatever. You could have some means by which the Michael Robinsons of the world with these bigger cases could, the rebuttable presumption comes up once they've provided some sworn affidavit that confirms that they have done that amount of work, or at least that amount of work.
I see what you're saying. So even under the rebuttable presumption alternative, there could be a requirement that the attorney provides an affidavit, and that will give it a little bit. That will give some more comfort to the judge.
In fact, it seems to me that the lawyer does it and then gets the rebuttable presumption that that's correct. Because otherwise, you'd get into just how much do they have to provide.
Right.
Particularly if it's not contested.
And I suppose under the presumption, if it wasn't contested, then it wouldn't come up.
That's true. That's true, but I could draft it so that if the attorney provides this affidavit, then they're entitled to that rebuttable presumption, if that sounds good.
Yeah, you can work on that language. Okay, any more thoughts or comments on the attorney's fees provisions and promissory notes and other evidences of indebtedness? Well, I guess we can move on to the next item, and we really appreciate all the guests who came and provided their expertise. It's been very valuable and very helpful. Thank you so much.
Thank you.
Thank you all.
Thank you. Have a good day.